Judge Annalisa Torres of the U.S. District Court has approved the U.S. Securities and Exchange Commission's request to extend the deadline for providing a response that might end the agency's action against Ripple Labs. This document is an official record that the court has released. According to court documents filed on March 1st, the Securities and Exchange Commission was granted an extension of time to provide the discovery documents it requested from Ripple regarding its remedies. As a result, the regulatory authority now has until March 22nd to provide its opening brief. Additionally, the SEC now has until May 6, 2024, to submit a response, and Ripple now has until April 22, 2024, to submit an opposing brief. The SEC has requested additional time to accomplish the assignment starting in December 2020. Potential legal remedies and courses of action that could be examined or pursued throughout the investigation or litigation are explained in a briefing that is connected to remedies. The Securities and Exchange Commission filed a lawsuit against Ripple Labs. The lawsuit also claimed that the company, led by CEO Brad Garlinghouse and co-founder Chris Larson, had participated in an unregistered securities offering worth $1.03 billion. The company was able to accomplish this by selling XRP because the SEC believed the token should be treated as a security and was subject to stringent regulatory requirements. However, Ripple maintained that XRP is not a security and that the SEC, according to Ripple, the SEC did not provide them with enough notice. Over the years, there have been numerous changes to the legal dispute around the test used to evaluate whether a transaction meets the conditions for an agreement to invest under us. The law is the subject of a heated discussion from the SEC's point of view. Although XRP passes the Howey test, Ripple disputes that. A significant ruling in favor of Ripple Labs concerning its programmatic sales on digital asset exchanges was rendered by Torres in July 2023, when he determined that XRP was not a security. This was a significant turning point since the judge decided that XRP was a security coin after it was shown to institutional investors. The Telegraph has reached out to Ripple, but as of this writing, the company has not responded. Interestingly, the Securities and Exchange Commission has requested that Judge Annalisa Torres grant an extension of time until March 22, 2024, for the filing of its opening brief about remedies. There will be a single extension on the lawsuit, despite the possibility of a settlement between Ripple and the SEC. The SEC has delayed the deadline for their response from April 29 to May 6 in order to give themselves more time to review the discovery materials that Ripple has submitted regarding remedies. In the meantime, Ripple has been given more time to submit its opposition brief, which is now due on April 22 rather than April 12. The cryptocurrency known as XRP is adamant that the case is almost finished. A big change happened in the ongoing dispute between Ripple Labs and the SEC when a judge signed an order about the SEC's request to extend the deadlines for remedies-related briefing, opposition to briefing, and reply to the court's decision regarding the SEC's demand to extend the deadline, despite Ripple's opposition to briefing and the SEC's response to that opposition. According to a court record, the judge has granted the U.S. Securities and Exchange Commission's request to reschedule the dates for remedies-related briefings. According to our research, the Securities and Exchange Commission requested that Torres be given an extension of time until March 22, 2024, instead of March 13, 2024, to file its opening brief outlining remedies. The CCC now has until May 6 to submit its response, while Ripple has until April 22 to file its opposition brief. Due to previous extensions from April 29, the case is now 1 week behind schedule. This gives the SEC more time to examine the discovery papers that Ripple submitted on remedies. Institutions were obliged to sell XRP and furnish comprehensive financial accounts. However, Magistrate Judge Netburn had earlier allowed Ripple's motion to delay the disclosure obligations relating to remedies by 1 week after the action was filed. The XRP, while Ripple and the SEC continue to discuss potential settlements, the Army is optimistic that the case is coming to an end. However, a measure to avert the partial government shutdown has already been sent to President Joe Biden, and the SEC deadline falls on the same day as the government shutdown last week. $1.07 billion was invested in Bitcoin ETFs, and a Bloomberg analyst predicts a decline. The verdict in the case of Ripple versus SEC is drawing near. The price of XRP has increased by more than 8% in the last 24 hours, and it is currently trading at a low point for the past 24 hours, according to advocate and lawyer Bill Morgan. He also stated that the fact that one asset class is distinct from another does not justify an extremely complex and wide-ranging application of the Howey principle. In contrast, trading volume has increased significantly over the last several days due to a widespread rally in the cryptocurrency market that is strong relative to the same time period. The SEC's ongoing litigation against Ripple Labs has been granted an extension by the Torres judge. The XRP debate has now taken a different turn. The Securities and Exchange Commission (SEC) accused Brad Garlinghouse, the chief executive officer of Ripple, and Chris Larsen, the executive chair of the company. The American payments company accomplished this after securing a partial victory in court. The deadline for the SEC to file its opening brief is March 22nd. The regulator's request for more time to submit its discovery papers regarding remedies is a crucial step that could lead to the conclusion of the high-profile case, according to a report released by the Kendry last year. According to records filed on March 1st, Judge Torres approved this extension of time on March 22nd. As a result, Ripple now has until April 22nd to submit its opposing brief. Concurrently, by May 6, 2024, it is anticipated that the SEC will deliver a thorough paper describing potential legal remedies and measures related to the ongoing dispute. This document is known as a remedies-related briefing. The SEC filed a lawsuit against Ripple Labs in December 2020, alleging that the company's CEO Brad Garlinghouse and co-founder Chris Larsen were involved in an unregistered securities offering involving the sale of the $1.03 billion XRP cryptocurrency. This marked the beginning of the conflict between Ripple and the SEC. If XRP were regarded as a security risk, Ripple would vehemently argue that a recent development has led to the burning of XRP coins on the XRP Ledger blockchain. According to the most recent data from the XRP scan, the amount of burning has increased to an unprecedented level not seen since the middle of January. A startling 6,721. The price of the well-like token has skyrocketed, and more burns are occurring at the same time. Even if there was a temporary setback earlier today when a wave of selling momentarily wiped about 9% of the price gains, XRP has not only climbed by more than 15% this week, but it has also painted an excellent weekly candle on its price chart. Buyers' perseverance soon drove the price back up to 0.624 per token. That's it for now.